Welcome guys to our research session. Just FYI, in case anybody is presenting here in the future, they've done a little change-a-roo, so we're getting used to it. We have to use the screen and not a presentation screen and some things like that, so as we're getting used to it, be patient. So we have Dr. Francis Farrell here, who is the Director of Research and Development. And he is here to talk about pursuing research with an external collaborator. Now, you've heard me talk ad nauseum about the fact that very, very rarely are there research projects that you do just in isolation all by yourself, right? And a lot of us are familiar with doing collaborating with internal individuals and just working with folks within your department, even cross department. But there's really a push, and I congratulate anybody who's worked with external individuals up to this point. But there's a push for anytime I'm looking into either publishing somewhere, applying for a grant, or I'm reviewing a manuscript or reviewing a grant, more and more frequently there is a line item on there that's a lot of points typically that says, does this grant or manuscript or project involve external collaborators, more than one institution? Does it include more than one profession? Does it include more than one institution or organization? And if so, you get a lot of points for that. Not to mention, it's just really good research. It increases your N, it can do a lot of things. So Dr. Farrell is here to really help us to learn more about what that means and how to do it effectively. Right?
Yeah, thanks for the introduction. So the material, it really is kind of dry, but let's not make it dry. Please interrupt. And the second thing I'd like to bring up is, most of you know that I actually come from more of a corporate background, from an academic background. So the first thing you're going to do is to say, oh, this is all what you do when you work with a corporation. Every slide was taken from universities. So what universities now, most of them now operate like a corporation. So everything you see, a lot of it came from Harvard. I looked at Penn's. It's all consistent. So I just thought I should give that note, that this isn't just the way you do it if you're working with a pharmaceutical company. So the course objectives is how to foster and initiate collaborations with an external partner, the necessary contracts to initiate working with an external partner. The good news is you actually don't make that decision. The R&D office or lawyers make that decision. I can tell you the process. How to share data and reagents with an external partner, because sometimes you might really just be sharing a reagent. And how to define a research collaboration from independent contractor arrangement. Because one of the main things that can happen is if you have a collaborator and you send them an independent contractor agreement, the first thing they're going to do is going to get highly mad, because an independent contractor agreement restricts their ability to patent and publish. So you have to really be careful. And that's the decision we usually make, it whether you're collaborating with somebody or using them as a contractor. So I'll talk a little bit more about that. So why collaborate with an external partner? This is very, very simplistic slide. Collaboration drives innovation. Interesting, everybody knows about Watson and Crick. Brown and Goldstein, even though those two were in the same institution at UT Southwestern, they put their heads together and solved the whole LDL pathway of the LDL receptor. Both won the Nobel Prize. And so that's a real good example of two guys, sharing the task and leading to a Nobel Prize. I looked up Procter & Gamble. That was actually two brother-in-laws. And so two brother-in-laws came together and formed their company. The other reason why you really need to do an external partner is what we're finding is people want to work with us because they want to do translational research anytime now. You want to write a research grant. If there's really not a translational research component to it, you're likely not going to get funded. So this is that concept of bench to bedside and maybe back to bench. So we do a lot of translational research with Virginia Tech, for example, because they generally have done large basic science R01 type funding. Now they're finding they want to do more things that are like a clinical trial. And then last thing is professional development. You want to increase your publication and your funding opportunities. It's always good to be associated with somebody that publishes a lot. I know when I did my postdoc, within the first couple months I got a PNAS paper, which is kind of a big deal back then, and it was just because my boss was collaborating with somebody that was a member of the National Academy of Science. So that's one reason why I really get people to collaborate. So mechanisms to foster collaboration, personal communication, obviously. What I found in my past was when I was actually doing bench research, is the poster sessions at conferences. So I really think it's good to travel. And when you go to poster sessions, you're there with the speaker, he takes you to the poster, and you can kind of get a dialogue, you meet face to face, and then you follow up, after the meeting. Lit reviews, it's good, to send, cold calls / emails. Professional associations, especially if you're doing any survey-based research. I work a lot with thank you, Carly, for coming. There's some IRB slides, so it's good that she's here. Professional associations. So I work a lot with the Jefferson College of Health Sciences students, and a lot of them are doing capstone projects that are surveys. And once they get a clearance to do their survey through a professional organization, they go from a survey this big to a survey that can go out to thousands of people. And we can all make that happen. I'm actually a big fan of LinkedIn because I don't save emails from 10 years ago. I barely save them from 90 days ago, as you know. But I always find LinkedIn, you just need to know the person's name, send them a note, they come back to you, then you say, what is your email again? Because you don't want to be collaborating through LinkedIn. But I found LinkedIn is a good way to connect with colleagues that maybe you've fallen out of touch with. Networking through your colleagues, both internally and externally. And the other thing too, think global, act locally. I put that in as, I find it funny when people will they'll make a collaboration with somebody on the other side of the country, and we're actually doing something here. Go ahead, yeah.
No, I have a question about LinkedIn. I keep receiving requests for different people that I don't know. Do you accept, or should you be? I guess my question is, when you look at somebody LinkedIn, is that supposed to represent what you really connected? Because I have requests for students, people that I really don't know who they are, so I don't know if I pay attention, if I accept, or I have a tendency not to look.
So what I generally do, and this is my personal opinion, is I don't accept all of them, but usually it says you are connected with, you and this person are connected with 10 other links or something, and that usually I make the connection. And so, if I'll send out a LinkedIn invitation to somebody in Carillion Clinic, and then it'll come back and they'll say, do you want to connect with one of you guys? And I say yes. So I don't accept all of them, but I do sort of screen them and use best judgment. And if it's somebody that I think maybe I should be associated with, like a research director at another institution, I always accept that. So, is that what everybody else kind of?
I think for LinkedIn, if they're in a professional field, then usually accept. I mean, there's not a whole lot of private information about you on there that somebody can't get. It's not like Facebook where they can mine photos and stuff.
Yeah, I guess my question is, I'm wondering if this better represented what my really interests are, or it's better just have a big community. Because I'm a faculty, and then I have requests for people doing stuff completely different than me. Is that okay? Is that a good thing? To have other people doing other stuff, like marketing and stuff that
I think LinkedIn is
don't know anything
way
about
bigger than just for research. It's got so many. But if you have in your mind what you want to use LinkedIn for, if you want to use it just
I'm not sure what I want to use it for.
Yeah, it's a personal decision.
Well, where were you previous to Carillion?
VCU.
Okay, so that's too easy. Well, I was with the company at J&J. I don't remember I didn't keep track of all their J&J email accounts, but I know their face, I know their name, and I could say, hey, Jackie, such and such, and then she gives me her J. And I know the stem, but J&J, it's usually first initial, then 7 letters, and there's a 1, 2, 3. I'm not going to remember all that. I don't keep it in a little black book, so that's my little safeguard. As long as they're in LinkedIn, I have a connection. So go ahead and initiate that conversation with an external collaborator. Don't share too much. Don't give anything away. But generally start working about that. But what I think is a good thing to do is to complete a research and development application. And what we look for is the section called non-Carillion collaborator contribution, including students. So when that comes into the R&D office, we immediately look at that and try to ascertain, A, what this person's role is and what type of agreement needs to be put in place. And so here's just some notes right here. So that gets it started, something you don't have to do. We do that for you. So What the Carillion Clinic Research Development Office is to determine what agreement is appropriate for your research. So one of the things too that I find with a lot of nascent researchers is that the contract and agreement is negotiated between the respective research offices. It's not between investigators. So you should never sign anything on behalf of Carillion Clinic in your own name, because now you're liable, right? So if something goes wrong, you've said, yeah. And so we kind of have little mini fights with some of our investigators who want to sign their own agreements, and we try to tell them it's in your best interest not to sign it. So ours is called the R&D office, but in some other places it might be the technology transfer office. It could be called grants and contracts, clinical trials office, or sponsored clinical office. But in some cases too, it could be the IRB, the Institutional Review Board. So here's a key figure too. If you go to any site working with the Collaborator, they're signed by the institutional signature authority. So every institution has that, and our institution is Dr. Daniel Harrington. So Dr. Harrington looks at these and signs it basically on your behalf. So he's our representative. So again, you don't need to know all these, and we have templates for most of these, but this is right from the Harvard site. So when you receive, share, acquire, generate data, it's going to require an agreement or a contract. And for most of these are agreements where confidential information is exchanged, including the following. So non-disclosure agreement, that generally you don't need that when you're working with an academic collaborator. You will do it when you're working with a company. They're going to say, could you sign this non-disclosure agreement? Again, send it to our office. The nice thing here at Carillion, we actually send it off to Charlottesville, lawyer Bill Define. He does it overnight. Next day, he says, yep, this is fine. If there's any changes that need to be done, signs by Dr. Harrington, and you're free to go. So that's the non-disclosure agreement. So I know that you, as an investigator, will get these. Just send them to our office. Sometimes they're also called a confidentiality agreement. So material transfer agreement, or MTA, that's the other thing. There's a lot of acronyms, so that's why I put in there an MTA. That's generally if you're just transferring a reagent. So anything that goes in, out the building or comes into the building really should have a material transfer agreement associated with it, especially if it's a drug substance, an important reagent. Specimens, right, yeah. Because what happens is that you're doing a research study and you're sending them reagents. You don't want them to take the reagents and now give them to a third party or do their own independent research, because it'll state in the material transfer agreement, this is just for this study or studies, for example. Clinical trial agreement is real common when you're working with a sponsor or a pharmaceutical company or a CTA. Now, research collaboration agreement is one thing. We do a lot of these, and generally all the agreements with an external party where it's a true collaboration, it's a research collaboration agreement, RCA. So just to give you perspective, when we work with a tech person, we need to put in a research collaboration agreement. We work with a med student. There's a research collaboration agreement, so they're not Carillion employees. Jefferson College presently is a Carillion employee, so you don't have to put in an agreement. And next year they'll be Radford. The independent contractor agreement is what you give to somebody that's providing a service for your study, but they're likely not going to be sharing in the publications or their intellectual property. So we really make sure that we only give these to folks that that need them. And I'll give you, for example, most of you guys know Douglas Grider. He's with Dominion Pathology. We generally do a research collaboration agreement with him, even though we're making the agreement with Dominion Pathology, because he's not Carillion either. But the reason why we do an RCA with him is because Doug is an active intellectual contributions, will be part of IP and part of the publications. So we have made a mistake before and sent an ICA to somebody and they got extremely mad, because it's kind of insulting if they're a collaborator and you're sending them an independent contractor agreement. We're starting to do a lot of these now, these master research agreements, both with academics and with companies. So we've done one with the University of Virginia. We're going to do one with Virginia Tech. We're actually going to do one with Dominion Pathology, so that speeds up your ability to start working with Douglas Grider. We're right now negotiating one with Siemens, so that we can actually do numerous studies with Siemens under a master research agreement. And then there's something called a certificate of confidentiality, which Cassandra just recently had to do. Do you want to spend a minute talking about that? These are two you.
Sure.
So as far as I know, the certificate of confidentiality, this basically protects us from if we're collecting sensitive data about narcotic use. And so if the patient was in a car accident or something and they wanted to subpoena our data, this is our protection. And there's, limits to that protection, but that's, so it's nice to have. And we applied online. It was super easy to get. It didn't take very long, and I was surprised how easy it was to get it for non-NIH funded research.
Yeah, because you apply through the NIH for that.
Yeah.
Okay, any questions on that? Thanks for doing that. The other types of agreements that permit or prevent unspecified future uses of the data or unspecified secondary uses of data. So we do a lot of these data share agreements, data use agreements are mostly the same. And then I'll talk a little bit more about the business associate agreement. So the data sharing agreement could actually be PHI or non-PHI. It can be a limited data set. So that's another thing that we sometimes, these are usually associated with a protocol in most cases. I know Dr. Sorrentino recently did a study, and he wanted to collaborate with a collaborator where they really were just doing non-PHI type data. And so I said, you really should put a data use agreement in before you send anything out. Now, his collaborator sent it in. We can't restrict that, but I told him basically now the data is contaminated. So it's just a good practice to have a DUA or data sharing agreement in place. So a lot of times this is too when you're like peripheral to the study. Business associate agreement is when there's PHI involved and you're not part of the covered entity. So I'm not going to, okay, I'll talk a little bit more. We'll talk a little bit more about that in the next slide. So agreements often associated with a third party include this following: a service provider or a data storage agreement. So when we start doing cloud storage, you put an agreement in with Amazon or Microsoft Azure. A memorandum of understanding, I sort of think of those as a soft agreement. It's basically we're going to agree to work together under these terms, and then we'll do the contract later. So to give you a good example of this, we've initiated a memorandum of understanding, or MOU, with the RAMP, the Regional Accelerated Mentoring Program, if those folks want to use our lab. So what that just says is that we'll negotiate in good faith with each individual company. But when we do the work with the company, we have this in place as the umbrella agreement, and then there'll be separate agreements underneath it that reference the MOU. A cooperative research and development agreement has to do with grants, and then also too, you're going to start seeing more of these consortium agreements where, recently went into a member agreement with Trinetics. It's a company that's going to be looking, we're going to working with them with clinical, de-identified non-clinical data. I can envision in the future that we'll open this up so that we share data between the other CTSA grantees or people that run this grant that would be like VCU, UVA, etc. So let's talk a little bit about a research collaboration agreement, because that's the most common one. That's a contract between Carilion Clinic and the external party, stating that the PI and the sub-I, the external partner, wish to perform research per the terms of agreement. Again, we do this all in the background. You don't have to do that. So there's a lot of boilerplate things on there, but the ones that protects you and protects the collaborator is what's the publication plan. And sometimes some of these RCAs state that if the study's over with and the other person hasn't published anything in 90 days, you're free to publish as much as you want. It also states how the publications will be formulated, not necessarily who's first author, who's last author, but anytime I want to publish, I need to show it to you and vice versa. That's all the language that we put in there. Confidentiality we put in there. So that's something that when the contract goes out to the other site, they have their lawyer look at it too, and they do what's called redlining. It goes back and forth. You track changes, and in the end, we agree to agree, and then that gets signed by Dr. Harrington. Intellectual property is a big one. So intellectual property, just a rule of thumb, is what's ours is ours, what's theirs is theirs, and what we do together is both of ours. We share equally. So that's sort of the standard IP language that everybody agrees to. Liability insurance, obviously, if you're doing human substance research, that needs to be stated out. And then right here, signatures by Carilion Clinic and the external party. So again, you do not want to sign a research collaboration agreement. It gets signed by Dr. Harrington. The other form that you'll know is called a SOW, or Statement of Work, and usually this is the exhibit. So again, this is mostly going to be boilerplate type stuff. That's the template. And on the back end of that is going to be what's called the statement of work. Sometimes it's called Exhibit A. And then there it's going to have the effective dates, the names of all investigators and contact information, trial parameters, what's the compensation, a little bit of the study design. When I say study design, it's more like an Excel spreadsheet. What's your role? Who's the name? What's the role and responsibility? And then the study milestones. You will need this too for your IRB application. Right, Carly, the statement of work. So it's good to kind of do it in tandem. That's something that you, for the most part, fill out. The RCA part you don't. So here's the Health Insurance Portability and Accountability Act. So HIPAA applies to covered entities. So all of us, I guess, in this room are Carillion employees. So we're part of the covered entity. When you work with an external collaborator, they're not part of the covered entity. So when you're transferring PHI information outside of the covered entity, you have to have what's called a business associate agreement, or BAA. So this isn't a Carillion specific thing. This is federal law, and there's severe penalties. We're not doing that. So compliance folks usually have a hand in looking at this and determining. So the two things, a BAA has to be PHI, and somebody has to be doing work on behalf of Carillion. So if they're not doing work on behalf of Carillion, then you can do a literature search. There's papers around what constitutes a BAA and what doesn't. For example, if you have a sample and you use FedEx to, you're sending something by FedEx. Do you need to have a BAA with FedEx? The answer is no. So there's certain things that aren't covered, even though they're doing service for Carillion. So it's, again, that could be a whole other topic. I usually don't get into that because that's something that compliance really wants to own. Did you have a question, Ryan? Maddie, did you want to, Matt, I was just with Maddie. So Carly, would you like to comment on that?
I was just going to say, if somebody's utilizing PHI for purposes of doing work for you, like so Solstice, if they're going to have PHI for the samples, then you may need a business associates with them. If you're working with a collaborator and you're truly collaborating, then that would be more like a data use agreement or collaborative research agreement that would outline those things.
So again, we're not experts in all this, but we've retained 2 clinical research lawyers that are external Carillion. They get paid by Carillion Legal. They're quite good, so they understand. This is what they do for a living. There's a quick turnaround. So I think we actually have a pretty nice system the way we work. It's a 2-person law firm. They only work with the nonprofits, academic centers. They don't work for pharmaceutical companies. So every contract that goes out the door gets reviewed by them unless there's been no changes to it. So this is the business associate agreement. That's usually what I call Exhibit B. So it's the BAA is a contract between the HIPAA covered entity, us, and the HIPAA business associate who you're working with. And so it protects PHI information in accordance with the HIPAA guidelines. And again, it's signed by Carillion and the external party. And here is more information. So I think you guys have access to the slides. So the other thing too is request for access to protected health information. So not only do you need to do this, but you want your collaborators to have access to that. So what you'll do is, this is part of your research application. You'll general study information, type of information requested. This is one document that you do sign, and in most cases you provide your driver's license to prove you are who you are. And then you sign the access and confidentiality agreement, which is on the website, and we'll send it to you so that you can have EPIC research access. So right now, what we did is once your protocol has been IRB approved, this is Maddie Tenser's group, they work closely with the IRB, and they'll only grant access, EPIC access, if it's the IRB protocol, IRB application is approved. So we kind of have a nice system where we all work together on this. The PHI, if you have any questions about PHI, Christina Cooper is the research compliance officer for Coding Clinic, reports to Vicki Clevenger. Carly Emerson's also a very good resource for stuff like this. You want to say anything else, Carly? Get you So this is where I'll get Carly's input. So when you're working with an external collaborator, who is the institutional review board of record? Well, it's not, there's no iron fast rule who is and who isn't. So that's one of the things that needs to be determined. Sometimes it's determined for you, but it's a conversation that needs to be had. It's good to have a reliance agreement already in place with the person that you're working for. This is a definition that I pulled out. It's a document signed by 2 or more institutions engaged in human research to prevent 1 or more institutions to cede review to the other. In some cases, you might be using a third-party IRB, or the Western IRB or WORD. And then if there's human subject research, the institution, this is just a generality, that's the source of the study participants is usually the IRB of record. Carly, take it away. Add something more to this.
So I think the big thing is if you're going to be working with a collaborator at another institution, to first talk to that collaborator, get contact information for their IRB, and then reach out to your IRB here at Carillion. And we typically, right now, we're small enough that we can still reach out to the IRB office, can reach out to the other IRB to determine who's going to be doing the review. Some IRBs are more willing to defer or to be the reviewing IRB than others. Currently, Carillion has the standpoint that if it's solely our patient data, that we will be the reviewing IRB. So if you're working with someone at Virginia Tech, they're maybe working on the social behavioral component of the research, but you're actually recruiting patients. Carillion would typically be the IRB, but it really is a case-by-case basis. And in some cases, you may need to go through both IRBs because neither IRB is willing to defer. And that does happen. There's been a lot of progress around this in terms of really trying to streamline the workflow between IRBs. And so the best thing is just to contact us early. There is Francis mentioned this reliance agreement. There is something called SMART IRB, which is a consortium that different organizations can enter into that takes out some of the paperwork that has to happen afterwards, but there still needs to be a review at each level and each side on each IRB to determine which the reviewing IRB will be. So the biggest thing I can say is just, contact us early in the process so that you don't end up, sometimes we have people who submit to one IRB and they say, you're going to be the reviewing IRB, and we look at this and we say, no, we're not. We need to talk to Virginia Tech, or we need to talk to VCU or whoever it is to determine who the reviewing IRB is going to be. And then if something does change, if that the way that you thought it would progress doesn't, then you may have to do another IRB application, or you may have done all this work for no reason. And so the biggest thing I can say is reach out to us early. Tell us you're going to be working with a collaborator, who that collaborator is, and ideally get contact for that IRB as well. We can typically find that online, but it's a lot easier if you have it for us. Some institutions specifically have someone, that one person that full-time just deals with these reliance agreements, so that's the person we're going to reach out to.
I think as a general rule, again, I don't want to overstep my bounds here, that if you're working with somebody at University of Virginia and it's already been IRB approved at UVA, talk to Carly, because don't just immediately fill out the application, because you might likely not even have to do that, and you can work out an agreement on what information is necessary.
Yeah, and there still is an application, but it's a lot more brief. We're going to an electronic system. There'll be a way in that system to actually request that you do rely on a third-party IRB, and you can upload, if they have a protocol already approved, you can upload that as well as the approval letters from that other IRB, and that way we can see that it's already been approved elsewhere, and that simplifies the process a lot. We still need to contact them and ask them if they're willing to review our component. It's also a lot easier if your research is, if it's a true collaboration, or if the research is identical to another institution. If this is a large multi-center study, but you're only doing one small component of it, or doing something that other institutions are not doing, then it may be harder for that IRB to agree to be the reviewing IRB, because there may be something that they're not as familiar with. So it really is a case-by-case basis.
Yeah. Thank you for all that insight. So data management is access and collaboration. So this is, I'm probably not going to give this enough time to really talk about this, but this could be a whole separate research session. But there's something called, this is from the Harvard site, the minimal necessarily principle. So the least amount of privileges. So be clear on the personnel who will collect or work on the data. Not only this is on your IRB application, your statement of work, it's really just good policy. It's different from I always think of when you go into publication mode, you throw everybody's name on the publication. It's not that way with the protocol. It's not that way when you're actually managing data. But in some cases, this will be an application whether the data will be accessed. Can it be accessed remotely, de-identified, identified? The DUA in the data sharing agreement will state the restrictions on the data, and then how data will be used in the future. That's a very important point. And if so, what measures will be taken to measure assurances of privacy, security, and confidentiality? So not only do you need to have this agreement, but other people forget too that if it's an active protocol, it has to be renewed every year. If you don't renew it, you can't really be analyzing the data because your protocol it hasn't been renewed, so it's expired. So all these things work hand in hand. And again, you get notices about things like this. Storage and backup, how's the data shared, tracked and documented, where's it stored, how it's protected? These are questions that you'll get from data privacy security. Could mobile devices be utilized? How's PHI stored? I'll tell you why I'm going through this quickly. Data backup plan and estimated size of the database. So when you fill out an R&D application, it gets reviewed by our health analytics research team, our HEART team, Maddie Tenzer and Min Wong. Generally what they're going to do is they're going to look at your protocol and you're going to tell you one of two things. Use REDCap or you don't need to use REDCap. So what is REDCap for people in the room here that don't know? It's a research electronic data capture, so it's a web-based tool for building and managing databases and online surveys. You can use it to collect almost any type of data. So it's free of charge to use. We have a license through Vanderbilt University. It's quick, easy, flexible, things like that. But what the beauty of using REDCap is it resides behind the Carillion Clinic firewall. So when you set up a REDCap survey or REDCap data analysis, all the data is behind the internal firewall. So that whole worry about leaving a laptop, your store's leaving a laptop in your car gets broken into, or spreadsheets that get transferred or sent in emails. If you use REDCap, all that goes away. So this is where the data resides, the PHI data. There's a web server that talks with that, that step. And then there's our external firewall. So that I think what's nice about REDCap is your external collaborators have access to the study if all the agreements are in place that we talked about, and they can freely work on it. When you send out a survey, you can send it to non-REDCap people because they don't need to have REDCap access to do a survey. So I think what we found is that most people they like using REDCap. I think it solved a lot of those things that they've had to worry about. I don't know, Cassandra, if you want to talk a personal story about using REDCap or not.
Well, we've just had a really good experience with it so far, using it to collect our data and manage patient surveys. But we haven't really got that much into the analysis part of it yet.
Right,
so.
Yeah. But the other thing too is that what folks tell me is that they can work on their data at home, as long as they're using the right type of computer and they log in through all that. So it's not like, again, it eliminates spreadsheets, which are just not a good way to store your data. It's not secure and it's kind of frowned upon. So that's just so. You talk to Min or Maddie, and they'll give you REDCap access, and it's just like doing a protocol. Who else needs access? They make sure that the right parties have it. What level of access they need. They might, if they're just doing the data collection, especially if you're working with an external collaborator, they don't need to see everything. They just need to see their part of the study.
It also improved the quality of our data collection because it warns if something's not the right format, or if there's a blank that shouldn't have been left blank, or if so it's certainly made our quality better.
Yeah. And so these are just the contact names. It's kind of, I would think it's easy. It's MM Wong or MM Tenzer. So it's real funny if you need to email those two. So it's kind of funny because I send those to a lot of emails. And again, we have what's called our own instance. Something that we're going to be looking at now is right now, REDCap's only being used for research. So we've been kind of leaning on the health analytics research team to open what's called a second instance, a REDCap that's kind of like not just for research. So we've still had those discussions, who's going to manage it, how much time. So they've actually talked to people. HR is even thinking about using REDCap because right now Qualtrics is very expensive, and we pay a huge license for that. So they were actually looking at using REDCap for some of their surveys. So, and that's not research. So retention, identifiable data should be held for a minimal amount of time necessary to conduct research, but also what the federal regulation is on that. And then corporate sponsored clinical trials will usually have contractual obligations on data retention. And again, there should be, in the data use agreement, is the disposal, return, destroying, and archiving. Again, Carly, do you want to make any statements on this one?
No, just ensure you're talking to your collaborators about who will store the data, where it will be stored if you are using paper forms, to ensure that the data is kept securely, who will have access to that. We'll talk about all that stuff before you get to the end of the study. What will happen if someone leaves the institution that they're with? Do you continue collaborating with them when they go to a new institution? It depends on if it's grant funded or not. A grant is funded to the organization, not to the individual. So if you're working with a collaborator in another institution who got that grant at that other institution, then that collaboration may terminate after you may have to find another collaborator at that institution and the project may stop. So just kind of talking through all those things up front.
How long do you keep the data after the research?
So it depends on your study. All data is required to be kept at least 3 years after the completion of the study.
That's where, who keeps the data? You guys or
No,
the
you do.
PI?
You do.
The PI. And you need to have a data security plan. So, it shouldn't be kept in your car or in your home. It should be in a locked office, in a locked building, ideally, in a locked file cabinet. So you'll want to think about that. And then if it's data that's covered under HIPAA, which most of our data is, it needs to be kept for 6 years after the completion of the research for HIPAA regulations. And so, again, you need to think about, if you decide that you're going to leave the organization, who is going to take on that responsibility of maintaining that data? Ideally, after publication, you can, if you're not going to be accessing it all that much because now your publication is done, typically the thought frame is you want to keep it a little bit longer after that in case there's ever somebody trying to replicate it or research misconduct. Somebody accuses you of research misconduct. If you have your raw data there, it's much easier to disprove research misconduct than if you just have your aggregate data.
But if it's done by REDCap, so I don't have to do total data.
Right. If it's in REDCap, then basically if you leave the organization, it's all kept in there. If you leave, then you would just, your access will be cut off to that system, which is another good reason why REDCap is helpful.
Yeah.
But I think this, from my past experience, and I did research misconduct investigations prior to being at Carillion, one of the biggest issues was afterwards authorship issues. So collaborators and authorship disputes at the end, which didn't meet the definition of research misconduct, but would often initially start to proceed through that pathway. So I think the really big thing is just to understand, make sure you have enough communications with your collaborator to understand everybody's role. And having some discussions about authorship on the front end is very important, but then also about who will keep the data and, once the study's done, who will have access to that.
Yeah. One thing that I find that makes it hard to do research in a hospital-based setting, so I was with Johnson & Johnson for over 20 years. To get in the building, you had to have key access, so it was restricted access. So in some ways, once you're in the building, it's self-contained. In a hospital setting, you literally, not to sound scary, but you leave your office to go to the bathroom and somebody goes down a wrong hallway and they can get into your filing cabinet. So we have to be a little bit more stringent here because it's so open.
And any data should always be kept twice locked at least behind a office, file cabinet, or building, office, that type of thing.
So that was a good segue to the next one. So before submitting, this is something that we've talked to the department chairs at Carillion, and they think it's a good idea. Before submitting or publicly disclosing, meaning putting in publication, you should ascertain if your data could be the subject of a patent filing. So that's not something that we do. So I think what we had at my last company is before you publish something, you gave it to the company lawyers, and if they had 2 weeks to review it, and if they couldn't get to it in 2 weeks, you were free to go ahead and send it to the publisher. The reason why this is important is once it's in the public domain, you can't patent it for most cases. It's a little different in the United States, but if it's publicly disclosed at a lecture, in an abstract even, doesn't have to be full publication. It's a publication. When you send it in like 6 months before the meeting, you basically have now eliminated your ability to patent something outside the United States. So, this is important. And the reason why this is important, just think if you have an external collaborator and you guys didn't talk about this and you're onto something, you could become an enemy with your collaborator because they basically screwed up, and you don't want to be the one that screws up too. So it's not a requirement here, and I don't want to make it a requirement. I think it has to organically become from our department chairs, but it's something that I thought And in most cases, you won't have anything that's patentable, to be quite honest, and then we can actually make a judgment. We'll have a patent attorney look at it for you. So just remember that goes through our office too. Check the information section to authors to ensure that you understand the requirements to publish in the journal. Like I know when I used to publish a lot, if you used a reagent that was native to your lab, you kind of had to be able to, the agreement was that you'd give it to collaborators if you had it available. You would share it freely. So that's something to remember. Obviously, you can't be sitting there making kilos of this compound, but if you had an important antibody, you really needed to share it in good faith. So make sure you read that. Also, too, there's rules about what they're going to do with it. So you sign over the rights of your data you give them the copyright, for example. So that's why if you see, when you publish something that's really an advertisement, has anybody ever seen that on a publication? The other thing too, publishing is expensive. Obviously, figure on it's about $1,000 a page. So if you're working with a collaborator and you get to the end, it's good to know who's going to actually pay for this thing if it's accepted. So try to develop an agreement with your collaborator. That's something that we don't handle for you. You something to do it informally. This is a big one here. If your data is placed on a public website, you want to consider the impact if your data is combined with other publicly available sources, so you can see where things get contaminated and polluted. So just be kind of wise on how you do things. Generally, if you're publishing in a reputable journal, you really don't have this problem, right? So. This I'm not going to go over. This is more sort of in Carly's territory. It's just, I put it since this is, you can't read it, but these are some of the terms that I think is helpful for you to do, especially if you're working with external collaborators or starting to do research. What's preparatory research, permitted uses and disclosures, what does de-identified mean, limited data set, HIPAA waivers, security rules. I think that's my last slide. Yes, that's my last slide. I don't know if anybody wanted to make a comment on any of these. I just put them in here some terms because it was part of this website. So yeah, look at this website if you want to see the full, all the discussion that went around this. But again, I want to make the point, this isn't, I didn't get this from some corporation. I got this from an academic institution. So any questions? Comments?
So,
Yeah, Bill.
Francis, in terms of educational research, let's say I wanted to do a study on VTC medical students. I'm a Carillion employee. I have an appointment at VTC, but they're going to be now a school of Virginia Tech. How do I choose what IRB to go through?
So the R&D office won't make that. We won't make that determination. We'll approve your study. We'll make sure the contracts are in place, and then it'll go to the IRB, and it rests with the IRB.
Okay.
And typically, most institutions will not allow a student to be a PI. So if you're working with a student solely, they will come through. We struggle there sometimes because then if you are working with a student or somebody that doesn't have PI privileges of another organization, they may have to find somebody at their organization to provide oversight and to be the PI, which kind of seems silly if they're not really going to be all that involved in the research. So
More that the students are the subjects.
the students are actually the subjects. So that would come through Carillion then. If the students are the subjects, typically the best practice would be to come through our IRB, and we would ask you to notify that institution to let them know that you're going to be sending surveys to their students or interviewing their students, and always send a copy of your IRB approval letter once you get approval. And then they may say, some institutions have very stringent requirements on that. So it may even be worth reaching out ahead of time to say, do I need to do anything with your IRB? I think for each IRB is a little bit different. In that case, if you were just working with the students, the students would not be considered engaged in research. So they wouldn't typically need to go through their IRB, but some IRBs do feel different. So again, the big thing is to communicate early. I know we have people contact us and say, I want to survey your nurses, or I want to survey your clinicians or something, and I always say, well, send me your approved protocol, send me your consent forms, we'll look at it. If I don't have any major concerns with it, then it doesn't have to go through a formal IRB submission in our office. But we do save the documentation in case one of our nurses calls us and says, hey, I received a survey about this, is this legit? At least I can say, well, we were aware of that. And there may be some cases where an institution would say, we're not going to allow that. And that was, previous institution I worked at, they were very limited, very controlling over the number of surveys that students received. Number one, if they were potentially sensitive information, they didn't want their students providing that information, or they also didn't want to overburden their students with surveys when they needed to do surveys internally, and there were internal investigators that wanted to survey students, and so they would quash those sometimes and would say, no, you can't, we're not giving you permission to send our students.
Yeah. I recently sent out an email to everybody in research, and it got blocked to Jefferson College because those have to go through Mark Lambert. One thing that's something that you brought up that I want to bring up, where it gets confusing, is we kind of determine where your W-2 comes from. So, for example, if it's a physician in nephrology, anesthesiology, pathology, all the departments that we don't actually have here, we treat them as an external collaborator. And sometimes we get into some arguments because it's like, but I have an appointment at Carilion, I have a Carilion clinic address, but you're not Carilion. So that still needs to be worked out as we move forward, but thanks guys. So that's something that right now you're treated as an external employee. And that causes some heartburn.
So part of the takeaway message is that although you've simplified this a great deal from what was mystifyingly complex before, the takeaway is if I want to do research with an outside entity, I probably need to call you guys.
Yeah, we do the heavy lifting for you, to be quite honest.
All right.
That's it, yeah.
Yeah.
I think it's good to start talking to, talking to that collaborator early on, figuring out, and then reaching out to Francis in the IRB office as well. And we can kind of say, well, we need a little bit more here before we can really determine what IRB it's going to go to, but, we can at least start thinking through some of those issues.
So I have a question about timing of this process. We've been approached by some students at Virginia Tech who are also collaborating with an exchange student in Holland, and they've made this, they're developing at the moment a device that automates measurement of hand range of motion. And so they're interested in getting input from us on some of the interface design and so on to make it as clinically relevant as possible. But also, once they've got a prototype, to have us essentially evaluate it, from a research point of view. Is it accurate? Is it,
Yeah.
So, first of all, does that even fit into research? I think
It may or may not,
can be,
and we can't set the rules, but what we could say is maybe we could say, you should document everything that you've provided to them or that that you, quote, own, whether that's in a lab notebook or it's recorded somewhere, because you don't want to give away your IP.
Right, but personally, I'm not trying to get financially into this.
Yeah.
Although I think it costs me nothing but a few hours to kind of give them some insight, which, but maybe that's the wrong thing. I belong to Carilion to a certain degree, and am I giving away a resource that Carilion owns? Sort of, I don't.
Your time, you mean?
Well, not my, I'm an hourly worker, so this is outside my hours. But, I know when I worked for universities that any idea that you had while you worked for the university was owned by the university unless they declined it. And I don't know if that's really true for Carilion, and this isn't really my idea. I'm just kind of telling them a little bit about how things work in a hand clinic. It's not original or anything. So I wasn't sure at what point. Obviously they don't want me telling everybody exactly how their device works or is going to work, but it's not like we've signed a contract over it.
Right.
But I'm obviously
And that's okay. One of the things that we've recently done is, maybe some of you guys know Victor Iannello. He used to be on the Carilion Clinic board. He's now a consultant for Carilion that's here to foster innovation. So he's actually talking with people that aren't even Carilion employees, because what he hopes is that we build this ecosystem of innovation, and maybe someday we'll license it from that collaborator. So it's kind of different. What I'd say though is if you do stuff, like you just said before, if you do stuff on company time, and it has to do with biomedical research, likely, you're basically doing it on behalf of Carilion, so we do need to have an agreement, or we need to basically do an invention disclosure.
So, so at what point in the process? because obviously you start by just like making the contact, you get to know each other, and at what point in this growth does it become,
So
okay, we're now
we
officially
can have a
collaborating
lawyer,
and...
we can have a lawyer talk, because again, we don't make those decisions generally. The word is, if you think a confidentiality agreement is necessary, we can draft one of those. I think true collaborations and stuff, I think it's okay to talk freely as long as you know that you are giving something away.
Right.
You're giving away ideas.
But again, if it's their device that they're
Yeah,
developing,
yeah.
you're just kind of providing a clinical expertise around that or some feedback, I would think that would
Yeah.
be okay. You wouldn't need it.
So a couple physicians now in pulmonology are collaborating with Virginia Tech, and so Virginia Tech, quotes, built a device, but really it can't go anywhere unless they work with our clinicians. So we're going to file a provisional patent, and it's going to be filed through Virginia Tech, and it's going to be jointly owned. I mean, that's way down the road, but there are mechanisms to work with folks. It doesn't really cost much either to put in what's called a revisional application if you think you are working on something for patent. It's about $300, and it gives you a year to work out whether or not there's something there, and it's worth pursuing what's called a non-provisional patent. So, and again, I'm older. In my day, information was very free-flowing, even though there was no internet, there's no emails and stuff. Now what I find is the universities are even worse than corporations. They think everything they do is great, everything is worth millions of dollars. And then they always think pharmaceutical companies have billions of dollars to give away too. And pharmaceutical companies, generally it's a very tight ship. Even though they make tons of profits, it goes to the shareholders. It's not, it's interesting. But I just know universities in some ways are more rigid than even working with companies. Because companies have been doing this forever, so they get it. They know what they're giving out, what they're taking in. So. All right, thanks for your time. If you have any questions.